The noble Lord invited me in his remarks just now to contribute at this point in the committee proceedings. I did speak at second reading, and I don't intend to repeat my remarks that I made then. But I would like to begin by saying to the noble Lord Steele, whose amendment I oppose, that he won't be surprised by that, but nevertheless, over the nearly 50 years that we've known one another, I've always been grateful for the respect which he has shown to an alternative view from the one that he puts not only now but has put in the past. And indeed I was particularly grateful when in my former party, that when this became a party policy, it was the noble Lord Steele who also resisted it becoming a party policy, because as he said, it would polarise attitudes and it would mean that matters of conscience would no longer be questions that people could follow as issues of conscience because of diktat from in party policy. So I have been grateful to him for that. Going back, and indeed 51 years ago, as someone at school, I wrote to the then leader of his party, the late Lord Grimmond, then Joe Grimmond, asking whether the abortion bill that the noble Lord had placed before the House of Commons was a matter of party policy or whether it was a matter of conscience. And I was given the forthright reply, there are different views about this, it's a matter of conscience. And so it was never a problem for me, as I think the only new member of the Parliamentary Liberal Party in 1979, to serve under Lord Steele and indeed to be his chief whip. And I would just commend this to the House, that this reasonable accommodation that I mentioned in my intervention to the noble and learned Lord earlier on is at the heart of what this debate should be about, how we accommodate one another. And I think that the noble Lord Winston made some very telling and helpful points in his intervention a moment ago. Noble Lord Steele said this isn't the way to go about this, but he would agree that 50 years later, many things that were never anticipated during the debates in 1967 have come to pass. And therefore, a proper review, perhaps outside of the proceedings of this debating chamber, is long overdue. A review of the legislation, of all the implications of it, and ways in which we can protect people like Mary Dugan, who spoke here in your Lordship's House, and whose case goes right to the heart of the debates we've been holding today. This is, as the noble Lord McColl said, an extraordinary woman who was involved in over 5,000 deliveries of babies, and who says, and I quote from an article, an interview which she gave, she says, "This isn't about religion, it is about conscience." She went on to say, "It goes against everything we stand for. The women I cared for would never, ever have known my views on abortion." And I think that this is very important, my lords. Here is someone who has been driven out of her calling in life. She didn't go into midwifery in order to carry out abortion. She went into midwifery to deliver babies. And I think that although I understand the reasons why Baroness Hale found as she did, and that my noble and learned friend Lord Brown of Eton under Haywood was right to refer to the judgment earlier on, it is up to this place, as the noble Lord Brennan has told us, to then deliberate and decide whether the law should be allowed to continue to stand in that way. Consider for a moment, my lords, changes in the law since 1967 and how they impact on people who may have a profound conscience objection to the law. One is, for instance, the extension of the Act in cases of disability right up to and even during birth. So on grounds of things like clubfoot, hare lip, cleft palate, let alone Down syndrome, with 90% of all Down syndrome babies now being aborted. If I was working as a medic and I was told I had to either participate by hands-on or alternatively by facilitating such things, I would rather lose my job than do that. And here I would disagree with the noble Baroness Lady Tong, who said they shouldn't join the service. Who do we lose, my lords, if we take an attitude like that to people who, yes, have a different view from the noble Baroness, but nevertheless are people who make an extraordinary contribution to the health service? Yes, of course I will.
This is a very interesting point. Then should they leave the service or not? I've had a very recent experience when my husband was taken ill and was dying and was taken to hospital, and we had to make a decision about whether to keep the breathing, etc., going or not. And I and my sons, we were there, discussing this matter. Now, it was a very difficult time for us, and the doctor in charge came and spoke to us and told us what the situation was. And we decided it wasn't the right time to prolong his life. Now, if he had said then, I'm sorry, I have to get somebody else to do the necessary job. I can't do it because I object to it. That would have been terrible. Now you can say he should have prepared for it in advance. How can he prepare for everything in advance? You don't know when a dying person is going to come into hospital.
Right, you can't ever say with any certainty about what will happen, how long someone will live, and our noble friend Lady Finlay intervened on that point earlier on, and at second reading our noble friend Lady Richardson gave another good case, a good example, which I can come back to.
Yeah, but Lady Finlay's example is perfectly correct. It's not about the same as my example. My example is that my husband had got into a stage where he really didn't know what was going on. But with Lady Finlay's example, of course it's a totally different thing, and it's a very good thing that people have hospices to go to.
Well, we are agreed about that, and the point I made at second reading when our noble friend Lady Richardson intervened on a similar point was that we do not need to go to heroic lengths, that's the phrase that often people use, to keep someone alive who would otherwise be dying. And I think we sometimes confuse these two things. But let me return, if I may, to the particular point about abortion. Of course.
Just very briefly, on personal explanation, I did not imply, I hope, that people should leave the service if they were required to do an abortion. What I was saying was there are many, many specialties to go into in medicine. My goodness, there is anything you can do in medicine, from management and pen pushing right the way down to, well, I won't say down to, because that would be demeaning to whoever I got down to. But there are many, many branches of the medical profession. There is no need to go into obstetrics and gynecology in the knowledge that you will have to do things that are totally against your conscience.
I was very grateful that the gynecologist who saw my own children into the world was someone who didn't support abortion, and that gave us a great deal of, my wife and I, a great deal of confidence in the lady who was our gynecologist. I think there should be scope within the service for people to have alternative views, and if the phrase that the noble lady used earlier on, don't join the service, were to apply, it would mean that people like that would not be able to join the service in the first place. Might also add that another change that has taken place in these years is that it was never envisaged in 1967 that this would happen on a regular day-by-day basis on the scale in which it's taking place. In fact, the noble Lord Steele often said that it would only be in rare and exceptional circumstances. There are now examples of some who have had 8 abortions in the National Health Service. And you have to ask the question, one which the noble Baroness often asks, is why isn't there more done earlier on to find alternatives to this? And I think that that too should be in the scope of an inquiry into the workings of the 1967 Act. So too should be the issue of gender abortions. If I was working in the National Health Service and I was told I had to facilitate the ending of the life of a little girl merely because she was a little girl, I would say no, that the 1967 Act surely doesn't allow for that. And yet we know that there have been such cases, and we know that the authorities decided not to take any legal action. Indeed, there was a vote in another place on a bill to outlaw such gender abortions. It was lost by 201 votes to 292. So this isn't the realms of fantasy, and noble lords do have to ask themselves precisely what their red line would be in regard to questions like this. Let me conclude by giving 2 opinions from people who have thought about these things in great detail. One is Professor Andrew Tettenborn, who said, "This point matters a great deal. Many National Health Service hospitals now put abortion and other controversial procedures out to tender, a matter itself a concern, and so organisation rather than participation is increasingly what will be demanded from unwilling staff." And I'd also refer the House Committee to the view of Dr. Mary Neal, Senior Lecturer in Law at Strathclyde University. The core purpose of any conscience provision is to protect individuals from having to share in moral responsibility for something they consider to be seriously wrong, since the current law leaves some of those who would share in responsibility unprotected. It fails to fulfil this core purpose. And so, when the Noble Lord said in 1967, the bill imposes no obligation on anyone to participate in an operation, I believe he was sincere in saying that. When he said the conscience clause also gives nurses and hospital employees a clear right to opt out, I believe that's what he intended. And I do not believe he intended that people like Mary Dugan should have lost her job. And that is why my noble friend's bill is so important.